the judge's ruling is very poorly understood. There are two pieces to the ruling, two halves of the decision. He was charged, and I've known Tom McCalvert for almost 30 years. I mean, he's a friend of mine. He's a very intelligent man, very good lawyer. And so this is, whatever I'm saying is not in any way critical of him. The Supreme Court asked the Superior Court, and McAllister was his lot in life to be the judge, to define what is meant by a free public education under the state's constitution, and in other words, what's the quality of the education that's required, and is the state funding that standard, whatever it is, adequately. That was the issue before him, and he ruled that was the core issue in the case, and he ruled completely 100% on behalf of the state. So on what the actual court case was about, the state prevailed hands down, and it's a very strong decision, and we did not appeal that half of the decision. The plaintiffs appealed that half of the decision. He could have, and in our judgment, should have put his pen down right there, because he had answered the question the Supreme Court had asked him to address. Instead, he pivoted and said that in 4 areas in particular, what the state was doing does violate the Constitution. Those 4 areas were, he said what the state is spending is adequately meets the $2.5 billion that goes in local aid, adequately meets the Constitution standard. But he said within that, so he says, don't expand the pie. You don't have to expand the pie. He said within the pie, it's being misallocated. It's irrational. He then said that for a couple of reasons that students with disabilities, special ed programs, were irrational and therefore unconstitutional. And then he said that there was insufficient linkage between teacher performance, teacher evaluations, and compensation. He said that was irrational. And then he said that social promotion within the school system, where kids are, promoted from 3rd grade to 4th grade, or from 8th grade to 9th grade, or getting their high school diploma, social promotion was too prevalent and irrational and therefore unconstitutional. One can agree or disagree to one degree or another with some of the points that he made as a matter of policy. There are some things he says that I might not be them irrational, but I might, if I were a legislator, say yes, as a matter of policy, we should make an adjustment here or there. Our position is that in imposing this new standard, it's judicial usurpation of the policy-making functions of the legislative branch and the power to implement those policy decisions, which is the purview of the executive branch. So it was judicial overreach in our judgment, and we have appealed that half of the decision. And so on the core decision, and we appeal that half not because he's necessarily wrong as a matter of policy on any particular issue. That's something that over which reasonable people can differ. But as a matter of constitutional interpretation, we think it's a really strong judicial overreach, and we've appealed on that basis.
But doesn't the fact that you could argue that his policy criticisms were accurate? I mean, some people said, well, the judge needed to overstep his bounds because the legislature's not going to fix it. Somebody had to do something.
Violate the Constitution?
If the legislature's going to sit on its hands.
And violate the Constitution?
Well, if you're a kid sitting in the schools where the things are messed up, you're still being injured while everybody's abiding by the Constitution.
Oh, we're a nation of laws and of the Constitution. And again, reasonable people can differ over what those policies ought to be. It's not, as State Attorney General, I'm not the policy maker. And if the legislature, many could argue, and in certain instances I would argue, yeah, there are things that they ought to be doing differently. But that's the power, that's the legislature's power. And I'm not going to bend the Constitution to meet policy objectives.